case, Bernstein versus Seyburn, Kahn, Ginn, Bess, and Serling.
Good morning, Your Honors. Michelle Thomas on behalf of the defendant appellant, Seyburn, Kahn et al., and Barry Bess. I would like to reserve 10 minutes for rebuttal, please. And given the straightforward issue of statutory construction we have today, I am willing to waive the 5-minute uninterrupted period and entertain questions.
At your peril.
I understand that, Justice Young. The court granted leave in this case, asking the parties to brief the issues of whether Michigan law does or should permit a continuous generalized relationship or service exception or extension to the 2-year accrual period set forth in MCL 600.58381. And did the plaintiff's allegations in this case of legal malpractice arise out of such a continuous generalized representation? The defendant's position is that the answer to both of those questions is no. With respect to the accrual statute, the legislature made it very plain when 58381 was enacted that accrual occurs, and I am quoting, at the time the person discontinues serving the plaintiff in a professional capacity as to the matters out of which the claim for malpractice arose. Our position is that language is unambiguous, a position we are able to rely upon given this court's decision in Gebhardt versus O'Rourke, and that it plainly rejects any extension or exception premised on some generalized relationship.
Counsel, good morning, and welcome to our new chambers. It's a pleasure to have you here. I just want to ask you a few questions, if I could, and I'm just trying to get a practical sense of this situation. And practically, if you could answer, when Mr. Bernstein, who is of no relation to me, I just want to make that clear.
So he doesn't have the advantage.
Oh, I like, Chief, that was good. I like that. But anyways, Mr. Bernstein, when he had any questions about his case or about how things were proceeding, who did he ask?
Well, I can tell you, Your Honor, that the record demonstrates that he did not ask Mr. Bess, who was corporate counsel for, the abbreviations we're using here are FHC and FAHC. He was a shareholder. However, at the time that he entered an agreement with Dr. Poss, who was the founder of these podiatry practices, he agreed to assign all responsibilities for the hiring and the communication with corporate counsel to yet a separate corporation owned and operated by Dr. Poss, DMC. And he admitted in his deposition that he did not, in fact, have any direction or control or authority to do so with respect to corporate counsel. So the answer is no. And I believe the exact quote in his deposition was, no, maybe once in a blue moon, but not as to any business matters related to the corporation.
So, counsel, you allege that there's no attorney-client relationship here, but I'm just wondering if that question is properly before this court. Has that been preserved for appeal?
Frankly, it's not relevant for this appeal because to the extent that we are denying, and we did in our complaint, the issue here is on the statute of limitations. So the assumption has to be that, you know, if it's legal malpractice, then there's an attorney-client relationship. We have never admitted that, and we do dispute that, but frankly, if there was none, then this statute wouldn't even be applicable. So this is,
right.
You know, we're arguing in the alternative, basically.
Right, but so you have two alternative arguments. One is there's no attorney-client relationship, and one is even if there was, then the statute applies. But have you preserved the question of the lack of attorney-client relationship?
Yes, it is in our affirmative defenses, and that's never been conceded. I guess what I'd like to emphasize is any arguments we're making with respect to the lack of a formal or actual relationship really go to the issue of whether or not there was continuous service. So if there's no relationship at all, then there's really no service at all, and that stems from the fact that the defendants were corporate counsel. They were not Dr. Bernstein's personal attorneys. They were not his attorney in his status as a shareholder. They solely acted as corporate counsel.
But on the question of preservation in this court, your Court of Appeals brief that you filed essentially conceded for the purposes of the appeal that there was an attorney-client relationship. So now you're in the Supreme Court. It's not properly preserved, is it?
Again, we made the same argument in the Court of Appeal, Justice Zara, and that is, of course, it must be assumed, if you're going to apply the malpractice statute of limitations, the underlying assumption is there was an attorney-client relationship, which was pled by plaintiffs. That doesn't mean there was. It just means it was pled.
For purposes of being in this court, though, it's not preserved, is it?
I also, as I said, it's not, frankly, it's not relevant with respect to an actual relationship, as
Okay.
to a duty owed in that context. The only relevance is that as a fact to flush out if there was a continuous relationship. And as I said, if there was no relationship at all, then it certainly couldn't have been continuous.
What is the we have the Levy case and others that construe this statute of limitations. So what's the jurisprudential significance of this case? Why do we care about this case, or should we?
Well, you should care because since Levy, the Court of Appeals have split as to how broadly 58381 can be construed, and whether, in fact, we get back to whether there's this continuous generalized relationship, extension, or exception. There is some language in the Levy majority opinion that seems to suggest that when the legislature enacted 58381, they wanted to broaden what had previously been known as the last treatment rule, which had been developed in common law and then adopted by the legislature, mainly for medical malpractice actions, later extended to other professional malpractice actions. And the focus there, again in the Kahn case, was whether or not when treatment ceased for the purpose of accrual, and in that particular case, there was a specific area of treatment, in fracture, leg fracture. And since then, the appellate courts have come down a couple ways. They've said, well, we got to focus on the specific service out of which malpractice claims arise. And others say, well, no, if there's allegations or evidence of some continuing relationship, that's the key, and therefore the limitation period doesn't accrue until the end of the entire relationship. To be perfectly frank, my clients are here to advocate adoption of Justice Markman's dissent in Levy.
So if Levy is not revisited, where are you?
We are still in an excellent position to seek reversal of the Court of Appeals because the allegations of malpractice in this case do not arise out of continuous generalized representation.
Okay.
They arise out of specific transactions over the course of 12 or more years, and each are independent and each are discrete, and all occurred more than 24 years ago.
Counsel, I thought plaintiff's allegations of malpractice involved not just the particular adverse actions taken in connection with the corporate entities, but also the ongoing lack of transparency and forthrightness that, according to the plaintiff, your client showed throughout the entire relationship.
Justice McCormick, I do not believe that is what is set forth in the complaint. And what the complaint does demonstrate and what discovery confirmed is that every single allegation of malpractice arises out of the formation of FHC in 1991, the formation of AHC in 1998, the formation of Sunset Boulevard in 2002, and then with respect to the supposed hiding of information when there was a meeting and Dr. Poss requested Dr. Bernstein to sign off on a waiver and consent, and that was in 2000. The complaint wasn't filed until 2008. And there are no allegations that, that there was negligence at any time other than those specific target areas of complaint. What the Court of Appeals relied upon and what the plaintiffs will urge today, I'm sure, is that the fact that Mr. Bess directed a letter to Dr. Bernstein in 2006 after the relationship was terminated as evidence of continuing services. But that letter demonstrates that it was written on behalf of the corporations and was really to warn Dr. Bernstein of activity he could not engage in once the relationship was terminated.
So when is that point at which the relationship was terminated?
Well, what
So
we
you
have
argue
here-
there's a point that this 2006 date came after the relationship was terminated. When was the relationship terminated? And also, I thought your position was there was no relationship. So,
What we're saying is there's no evidence of a relationship. There are allegations that there were. And plaintiff's position is this 2006 letter demonstrate that there was that relationship. But they don't allege any malpractice on behalf of the plaintiffs with respect to that letter or the termination of the relationship. And by the way, the relationship that was being terminated was between Dr. Bernstein and the corporations, not with the attorneys.
Counsel, can you help me understand a little bit more clearly what exactly the alleged malpractice was? It seems to me, and maybe I'm misinterpreting things, and if so, I'd really appreciate you correcting me, but it seems to me the thrust of your argument is not focused upon any discrete episode, any isolated or segregated act of malpractice, but it's really a function of the fact that you see a conflict of interest, and that conflict of interest kind of permeated the relationship. In that circumstance, is there really any discrete act that we can look to other than what occurred at really at the very end of the relationship to suggest that there was this moment at which the statute began to run?
Certainly, Justice Markham, because in this case, the plaintiff's damages flow exclusively out of Dr. Poss's activities once he regained his podiatry license, and then he formed a new corporation, at which point in time, Dr. Bernstein lost, supposedly, his fair share of the corporate shares.
But that was a function of the fact that it's unclear, in your view, who he was representing at the time, who was being represented at the time.
Our view is it's very clear. He's representing the corporations.
Okay, but it was an ongoing conflict of interest on their part, on defendant's part, was it not?
No. Again, I think the record that's been developed
I guess I
is...
just don't understand what the thrust of your concern is with the way that they comported themselves here.
Our point is it's not so much what they are claiming the wrongdoing was, whether there's a conflict, whatever it is. Instead, how did that manifest itself such that Dr. Bernstein was allegedly injured? His injuries come from, supposedly, his status as a 98% shareholder being diminished to a 50% shareholder. However...
But that's not the malpractice. The malpractice is that there was a conflict of interest, right?
They do not allege conflict of interest per se. What they say is the defendants facilitated Dr. Poss's decisions, which ultimately injured Dr. Bernstein. However, Dr. Poss had full and exclusive authority to direct the defendants to do what he wanted done, with, by the way, his practice, his money.
I guess I also don't understand, in response to the Chief Justice's question, what exactly you're seeking here. In the Levy case, both the majority and the dissenting opinions focused on the same language. I think they focused on the appropriate language, the as to the matters out of which the claim for malpractice arose. One side interpreted that a bit more broadly, and the other side interpreted that a bit more narrowly. Even if you have feelings as to which result was the more appropriate result in that case, how is that kind of difference susceptible to a change in the jurisprudence of our state? What exactly would you have an opinion say in response to your arguments? If you prevailed in this court, how would you articulate the new law as opposed to the old law?
Well, I think that the interpretation would be that the statute requires a focus when there's going to be a determination as to accrual on the specific and particular acts and omissions that give rise to the malpractice and not the termination of the entire relationship. Because the statute does not permit delay of accrual until the relationship ends. It does not delay accrual, and, expressly delay accrual. Yes.
The question is framing. The statute provides accrual at the time the person serving in a professional capacity as to matters, and I'll quote, out of which the claim for malpractice arose. The question then of framing under the statute is, what are the matters out of which the claim for malpractice arose? And it strikes me, the reason I asked the question about what the jurisprudential significance of your case is that what constitutes the matters out of which the relationship and eventually the malpractice arose is a fact inquiry.
Absolutely.
So ordinarily, we don't really care about facts. Not that we don't care about each and every one of the cases. We love them all. And equally without favor. But we are here to try as best we can to unsnarl areas of the law that are roiling. And I'm not sure what's roiling in this case that causes me to say levy needs to be revisited to clarify matters out of which the claim for malpractice arose. You may have a particularized fact pattern, but I'm not sure why it's legally significant.
It's legally significant because of the split among the Court of Appeals panels. And some have so broadly read that language and have relied upon levy to permit them to broadly read the language so that their focus is on the termination of the entire relationship.
But isn't that really the problem of how the statute is phrased? As to matters out of which the claim for malpractice arose. I mean, if you are going to the dentist serially, that's maybe there's a discrete malpractice that doesn't relate to a series of visits. On the other hand, if you are in a professional relationship with an accountant that has a series of audits or something being performed, maybe they're interrelated. But that's a fact question, is it not?
It is. And in this case, when we move for summary disposition, we provided documentary evidence establishing that the claims arose out of discrete and independent services.
Let me ask you my question in more focus. Is what you're seeking error correction, or is it jurisprudential? And I need to know the difference, how you define the one or the other. It looks and sounds to me like you want error correction. You think that the Court of Appeals made the wrong call in the framing of what the matters were out of which this claim of malpractice arose. Isn't that true?
That is true, but we also assert that the Court of Appeals was overbroad in their construction application of 58381 that allowed them, when they were then applying the facts, to seize upon a letter sent in 2006, which was not the basis of the malpractice claims. So to answer your question more forthrightly, we are seeking a jurisprudence impact here, asking the court to either overrule levy to the extent that it can be read as broadly permitting, or
let me try it this way.
clarify it.
Let me try it this way. Provide me with the thesis statement of the rule you'd like this opinion to have.
The statement would be, does Michigan law recognize?
No, not a question.
All right.
This is a statement of law. You want
All right, the
this
statement of law. Michigan law does not and should not recognize a continuous generalized relationship extension or exception to 58381 that focuses on anything other than the particular acts and omissions that underlie the malpractice claims.
So if we were to adopt that rule, do we have to overrule levy?
Not necessarily. I think it can be clarified
And how
pretty
would
readily,
we
frankly.
How would we distinguish your case from levy then?
In levy, the allegations were that the audits were interrelated, connected, and the defendants submitted absolutely no proof to dispute that. So what they had, so it came, as a matter of law, that was the fact pattern that was going to go forward. We did dispute any attempt to allege that there was continuous generalized representation and demonstrated that, in fact, there was a series of discrete transactional services related to 3 separate corporations. Again, we're dating back to 1991. And again, getting back to whether, the significance to the jurisprudence, if you carry the Court of Appeals opinion to its logical extension, if Dr. Bernstein were still a shareholder, his claims wouldn't have accrued yet, because they all relate, again, to the formation of FHC, to the termination of, or the dissolution of FHC. That occurred back in 1999.
But counsel, I have a question, and I'm listening very intensely to what you're saying, but based on what you just said, what steps then, going along with the chief's question, what steps then would you have to take to ultimately make that clarification known to the prospective client?
I don't see that there's any particular problem. I mean, we all deal with evolution of law all the time. I think back to the Fultz case that was later clarified in Lewicki. I'm a defense attorney. We had no problem advising our clients as to the status of the law. And prior to that, the split among the Court of Appeals panels as to how Fultz should be interpreted. And that's part of the system, and frankly, that's why I have a job, and so do you, to resolve these issues that come up. But getting back, I think, Justice McCormick, I think you asked more of a practical application here. I mean, it is absolutely impractical for any defendant to present a vigorous defense of claims that arose 24, 25, could be longer, years ago. I know it's on the record here. Mr. Bess's secretary was 89 3 years ago. I'm not even sure the woman's alive. And again, how do we defend a case when we've got to attempt to find witnesses that can recall that far back?
Counsel, recognizing that you're concerned that malpractice claims could remain viable indefinitely, I think that's the concern that Justice Markman raised in his dissent in Levy, but I guess I'm curious about, and I know this new statute's of little help to your client, but I'm curious what impact it has on the issue of jurisprudential significance, the fact that the legislature now has passed a new statute that appears to limit malpractice claims to 6 years.
Yeah, there was that 6-year statute of repose was adopted effective January 2nd, I believe, or 2013. As I indicated in our reply brief, the legislative history for the repose statute indicates that it was enacted as a result of lobbying on behalf of retired attorneys who wanted to be able to tell their insurance carriers how long they needed coverage, frankly.
So, again, what is the jurisprudential significance of your case in light of the limitation the legislature has just enacted?
The importance is how long are attorneys under threat of lawsuit if their claims arose before 2013. That statute of repose does not apply to our case.
Let me just make sure I understood what you just said. The jurisprudential significance of your case applies only to cases that arose before the application of the 6-year statute of limitation just enacted.
Well, it's the 6-year repose statute, which is distinct. I mean, there's precedent. Statute of limitation, statutes of repose serve different purposes. But it was enacted after this case started.
I understand that. Again, if it, from a jurisprudential significance inquiry, the significance of any one case, and only one case, doesn't implicate a jurisprudentially significant case, does it?
I guess maybe not for the particular facts, but as a matter of policy.
Let me say it in a slightly different way. Unless your case provides a template for cases that follow, it has limited jurisprudential significance. Wouldn't you agree?
If the impact were limited solely to legal malpractice claims in a very narrow window of time, possibly, although there's a case right now where leave is pending, that's presenting the same issue. There's another one where leave could be filed has to be filed by the end of the month. So we're not isolated, all right? And this is under, essentially this is statutory construction, limitations on the judiciary's ability to construe clear and unambiguous statutory language.
You have 5 minutes left. Do you want to reserve them?
Yes, thank you, unless there are any other questions.
Good morning. May it please the court. Matthew Turner on behalf of Dr. Bernstein. We're the appellees today. And I guess the first thing I would say in listening to my adversary's argument is that the fundamental thing that struck me is that she doesn't like the statute, that she finds there being problems with the statute, and that the statute allows for a result that she doesn't think is fair, which is that you can have malpractice claims that go on ad infinitum. She's right about that, but that's the statute. And as a court, as justices, your obligation, as you've said many times, is to interpret the statute as it's written. And if there are problems with the statute, it then becomes the duty of the legislature to determine if they want to deal with those problems or not. But until they do that, the court's obligation is to interpret the statute as it's written. I think that's exactly what this court did in the Levy versus Martin case. You interpreted the statute as it was written. We do know that the legislature has in fact dealt with this statute and has in fact dealt with the specific concern that counsel has raised in her brief and has raised in her oral argument today, dealing with the, that from a practical standpoint, we can all understand the difficulties of having to defend a case that might be 15, 20 years old, and so the legislature did address that issue. I think it's important in determining or looking at the intent of the statute, which is obviously one of the functions of this court, to look at what the legislature said when they amended the statute to enact the 6-year statute of repose. Because by doing that, they clearly, at least as I look at the legislative intent and the legislative history that they talked about at the time they enacted that statute, it was a clear recognition of the interpretation by this court in Levy that the statute did allow for malpractice cases to be brought many years down the road from when the specific acts of malpractice took place. That's why they came up with the 6-year statute of repose, to put a hard deadline on when cases had to be decided. And if you go back and you compare and contrast what the legislature did in 1986 when they passed the amendment to the statute for medical cases, where they talked about the statute in a medical malpractice case has to be, it runs from the act or occurrence that is the basis for the claim. Essentially what the defendants are arguing in this case is they want you to take the general professional liability statute that we're dealing with and graft onto that statute what the legislature did in the medical malpractice statute. Well, the court can't do that because that's not the language of the statute. The language of the statute, as I interpret the statute, and I think as the case law, particularly the Levy case and the Morgan versus Taylor case, allow for, is the word matters, the plural word matters, has to mean something. If the legislature wanted the statute to interpret to a matter, they could have said matter, or they could have said the specific act or occurrence like they did in the medical malpractice amendment in 1986. But they didn't do that. The statute as enacted talks about matters, and matters is plural, matters is a broad term. That's what the court recognized in the Levy case, and I think that's the correct rule of the law. And I think the court, as Justice Young, I think you asked my opposing counsel, what is the jurisprudential significance of this case? I don't think there is any jurisprudential significance of this case. Number one, I think the rule of law as it exists is not hard to understand. I think that the Court of Appeals got it right on the facts, but again, that's a factual question. But as the law exists right now, we have a statement of the law. I don't believe there's any difficulty in understanding the statement of the law. And in fact, if the court goes back and looks at and really analyzes the Court of Appeals decisions that have come down in the aftermath of levy, it seems to me that there's a pretty clear demarcation and understanding of what this court has done as it relates to the interpretation of the statute. And so the way I sort of look at it is we could look at this, the potentials, in two polar extremes. So obviously we're dealing with what has been generically called the last treatment rule, okay? So we could take one extreme of the last treatment rule, and we could say one extreme of the last treatment rule is it really means exactly that, which is that no matter what the matter or matters or what the lawyer did, if a lawyer continues to serve a client in any type of situation, the statute doesn't begin to run until that treatment ends. That's one end of the
Counsel,
spectrum.
I'm not sure you really help your own argument when you suggest that somehow matters can be equated with ad infinitum. Whereas my understanding of what the Chief Justice was saying was going in the direction of downplaying the significance of the differences in cases like levy. It seems to me your suggestion that these statutes can go on infinitum is not really a very precise way of putting what the difference between the majority and the dissenting opinions in levy were. If in fact they can go on infinitum, if in fact your interpretation is that the statute is consonant with an ad infinitum statute, I think there may be considerable jurisprudential significance to such an understanding.
Well, Justice Markman, if I just would be able to finish my sort of analogy that I was trying to draw, which is that the other end of the spectrum is the malpractice statute, which talks about the specific act or occurrence in the statute running from that date. What I think the court has done in terms of the way that it has interpreted the word matters, and what the Court of Appeals has done in the way they've interpreted the word matters, is to look at it pragmatically in terms of the Court of Appeals cases that have determined that the statute of limitations has expired, have looked at specific instances to see if there is a cutoff of the service. In other words, was there a specific representation on a specific matter that we can see ended by a number of factors to be looked at? Number one, some of the cases look at...
Let me try and get more concrete.
Sure.
Let's say that there's a attorney-client relationship. A lawyer's been advising a business client for 15 years, general business, and in year 10 of that 15-year relationship, the lawyer gives specific erroneous advice that 5 years later becomes problematic. It's exposed as malpractice. What is the matter out of which the malpractice arose in that fact pattern?
Well, I think it would, again, I think there would have to be a factual determination as to what the broad...
I've just told you. The lawyer gives broad general advice about business practices and real estate deals. And this particular one, 10 years into the relationship, they give malpractice. They commit malpractice, they miss something, and they gave bad legal advice about a specific transaction.
And is that specific legal advice on a business issue that's in the same class as the type of representation I was given previously?
They give generic and general business advice to the client. On one particular business deal, they gave bad advice.
And to answer your question directly, I would say that that's still part of the matters, as long as there's not, for example, let's say that there had been a separate representation letter where the lawyer says, okay, you're retaining me to represent you on this issue. The lawyer represents him on this issue.
No, that's not my hypothetical.
Right, I agree. Under your hypothetical, I think that is still included within the matters under the rule of law as stated in levy, and that would be within, and that the statute of limitations wouldn't run until the attorney-client relationship was severed.
So if that bad advice had been given in year 1 rather than year 10, that would still be, according to your construction of the statute of limitation, that would still be within the ambit because the relationship continued for 15 years thereafter.
I think under the statute, and I think that's what the court recognized in the Levy case, I think it's footnote 18.
How would we define what matter is then?
Excuse me?
If that's the case, if you have a general relationship where you're providing general legal advice to a client, apparently your view is that's the end of the inquiry. The matter, whatever happens thereafter, that's the matter out of which the malpractice arose.
Well,
Is that a coherent theory?
I was trying to get more specific than that, because, for example, let me give you an example in this case to try and flesh that out a little bit, okay? So in this case, regarding Dr. Bernstein, all of the representation that we're talking about here related to the operation of the podiatry practice. It had different names and different corporate statuses, but it all related to the operation of the podiatry practice. Now, separate from that, Dr. Bernstein also retained Barry Bess to draw up his estate planning documents. Now, if there was a malpractice claim arising out of the drawing up of the estate planning documents, that's clearly different than the corporate representation that was being provided as it related to the operation of the podiatry practice. So you could say that that's not the same matters.
I understand that. I'm just trying to understand this fact pattern
Yep.
that you are asserting what seems to be an indeterminacy so that you can't, if you have a general relationship as a lawyer with your client and you're giving a range of business advice and you flame out on one particular transaction in the business, the whole relationship is the matter out of which that malpractice arose, according to your construction. Is that what you're saying?
I don't think that's my construction. I think that's the Levy versus Martin construction. I think that's the construction
Well,
in...
Can I give you another hypothetical? Let's say I'm the general counsel of a large corporation. Let's say it's an auto company, and I get involved in all sorts of matters. You know, I advise my client on EPA compliance, and I advise my client on general business matters, and I also advise my client on specific pieces of litigation. We hire outside counsel to represent us in the courts, but I'm the general counsel, so my hand's in on, you know, various tort suits that happen. And with respect to a piece of litigation, I give just really bad litigation advice. But I'm the general counsel of the corporation, and I have been for 25 years. 25 years later, I'm still the general counsel of the corporation. You can bring the suit, what, when I resign my position?
Well, I would say that under the statute and the way the statute's written and the use of the word matters, and remember, going back to the whole, what is the public policy basis behind the last treatment rule? It is that the patient of the physician or the client of the lawyer is entitled to trust in the competency of the professional that they've hired, and you should not have to question the competency of the professional you've hired during the pendency of that relationship. So whether the relationship is 1 year or 5 years or 20 years, as long as the relationship is continuing.
You're just transforming matter into relationship.
Well, I think there's two things. There has to be two things. There has to be a relationship, and the matters have to be related.
I understand. If you don't have a lawyer-client relationship, it isn't falling within the ambit.
Right.
But you have transformed matters out of which the claim for malpractice arose into the relationship out of which the claim for malpractice arose. Are those the same thing?
No, they're not. They're not. You have to look at.
How does your argument differentiate between those?
Well, I was trying to get to that, and I think you have to look at is the allegations of malpractice related to the same types of matters, the same types of things, the same types of issues that have been part of the generalized relationship between these parties. Again, if Dr. Bernstein had hired Barry Bess or his law firm to represent him in a speeding ticket, well, that has nothing to do with the corporate relationship. Or again, if the relationship arose out of his estate planning, if there was an issue with his estate planning, that's a different matter than the corporate representation that he provided.
Let's go back to Justice Larson's hypothetical.
Certainly.
general counsel is generally providing all kinds of legal advice all the time. But on one particular matter, they give bad advice. Is that, I mean, it's a business
Right.
Call, a legal business call. It's within the ambit of what general counsel do. Her question was, is that general counsel liable until he or she resigns?
And I say yes. Under the statute, I say yes. As long, if that lawyer is general counsel, and that's part of what that lawyer does as the general counsel, and the malpractice occurred in that relationship as general counsel, then that's the matters, the generalized relationship, that's the matters out of which the malpractice occurred, and the statute says that you have 2 years from when that relationship ended. And that's what I think the statute, calls for.
Can I direct you in a different way?
Sure.
This all strikes me as being a shareholder oppression suit rather than a legal malpractice, isn't it? Why is this a malpractice claim? I guess I'd want you to explain to me what the evidence is of your client being anything other than a shareholder in this context rather than a client.
Well, but I'll answer that question, but let me first, I want to direct you back to the leave grant in this case, because in the leave grant, the court specifically stated what issue it was that it was going to consider and what it wanted the parties to address. That was not part of the leave grant.
Sorry, I'm a very curious justice.
I understand that.
Placate me.
I understand that. Well, because I think the evidence in this case, and again, my colleague disagrees, but I think the evidence in this case does support that there was an ongoing relationship of legal advice being given between Dr. Bernstein and his attorney, Barry Bess, who represented both him and the corporation. The corporation, by the way, of which...
As particularized as you can, explain, I mean, those of us who practiced law and advised business clients understand that there are lots of people associated with a corporation, but there's one client. Now, the fact that you might be advising the CEO or some officer of that corporation as to what they should do on behalf of the corporation doesn't make your advice to that particular officer a attorney-client relationship. So I'm trying to figure out how your client was something other than the recipient of advice to this corporation.
And again, I'll answer that question, but I would also just again state that that's not one of the issues the court indicated in its leave grant that was at issue for argument today. That being said, there were a number of factors that if you review Dr. Bernstein's deposition transcript, which is attached, there were numerous occasions where there was communication between Dr. Bernstein and Barry Bess about individual issues. And the one that I can really point to specifically is if the lawyer is giving legal advice to the corporation or to a shareholder or a employee of the corporation as it relates to something that affects the corporation is the client. If the lawyer is giving advice to someone that affects them individually, then they're giving advice to that person individually as a client. Bess gave individual advice to Bernstein, not just on his estate planning issue, but on any other legal issues or that he had individually relating to the corporation.
Give me for instance.
Well, when he would have an issue with POS, okay, so these guys were partners. When he would have an issue with POS, he would call Bess to get advice as to how he should deal with the issue with POS. Okay?
Legal advice or
legal advice.
Counseling?
Well, legal advice as to how he should deal with that issue with POS from a legal standpoint. Okay? In 1992, we have this, counsel in their brief gets the facts wrong in terms of what happened with the corporate relationship. But there's a memo in 1992 that Bess writes where he indicates that, okay, POS's legal problems are behind him, and now's the time when we should go ahead and fix the shareholder status so that both POS and Bess are 50-50 shareholders, and that never happens until fast forward till 1999, when behind Dr. Bernstein's back, Bess, in correlation with Poss, engages in this corporate shell game where he
So the general, I would just understand, the general statement, now that Poss's disability of being debarred is over,
right.
now's the time to put the two together on equal footing.
And for 9 years, they didn't. For 9 years, they continued to practice.
That's legal advice.
Right. That's legal advice. And for 9 years, they continued to practice with Bernstein as the 100% shareholder and the president of the corporation, and with Poss having no shareholder status at all, until they forged Bernstein's signature and behind his back. And this is what Bess did. This, you know, Poss directed him to, but Bess did it. They dissolved Foot Health Center. They established this corporation, Sharon Foot Center, did an assumed name to practice under the same name.
Those are shareholder oppression actions. I'm not sure those are malpractice actions.
Certainly there could have been a case against Poss as well, but that's not what we're here to deal with today. What we're here to deal with today is what was in the court's leave grant, which was whether the case accrued within the matters and the generalized relationship, and I think that's.
So you don't see any of my inquiry bearing on that question?
I don't. I think that's outside of the question of what the court's leave grant was limited to. Okay? Unless the court has any other questions.
Thank you very much.
Thank you.
Do you have anything else to say?
Justice Young, I think you put your finger right on the difference between the parties' positions here. And ours is the statute says matters, and that means specific matters, specific transactions, specific activities that form the basis of the malpractice claims, as opposed to relationship. Statute does not, and could have, legislature could have said, claims for malpractice accrue at the termination of the attorney-client relationship. It doesn't. It says matters out of which the claims for malpractice arise. And in this case, it's a great illustration as to how there can be matters.
If the court were persuaded that the Court of Appeals had too broadly interpreted this statute, what would you suggest a remand order to the Court of Appeals say?
Well, obviously, I'd prefer you just fix it. But if you're going to send it back.
We can fix it in a lot of different ways.
Pardon me?
We can fix problems. If it's an interpretive problem, we can fix it by putting the right frame on the remand order. What would that remand order look like if you prevailed?
It would direct the court to look at the specific acts and omissions on the part of the defendants, and when the services in those specific areas terminated.
You've gone past, I think, the text that says matters, and now you've started interpreting this more like it were the med-mal, where the specific matter. That's inconsistent with the language of this particular statute.
I don't find 58381 and 5838A to be that distinct. I think they're saying the same thing, and that is you look at the particular acts and omissions that underlie the malpractice claims. Those are the matters.
No, okay.
Okay, and in this case, the matters that they're complaining about, the matters that they're claiming legal malpractice occurred, are separate and distinct. And again, I wasn't being facetious when I say if you could fix it. The record is established. There's no dispute on that.
Just a moment.
About the record, I want to hear what you have to say next, Chief Justice.
Oh, go ahead.
It's good, but we're reviewing a C7 motion, right? And so we accept the plaintiff's well-pleaded allegations as true. We construe them favorably to the plaintiff unless specifically contradicted by documentary evidence. I assume you must have retainer agreements or billing statements or something that could have helped.
No, because, again, the defendants were not Dr. Bernstein's attorney, individual attorney.
Why would the retainer agreement then show that, or your billing statement show that? I don't understand why we don't have that.
Because again, the corporations were not the party here. All right?
I know, but you're responding to a complaint. And,
Correct.
And our reviewing standard is to construe these allegations favorably to the plaintiff unless specifically contradicted by documentary evidence.
Right, and our documentary evidence,
Contradict their allegations.
our documentary evidence establishes when each of the acts that they're complaining about occurred and when the last services would have been. When you've got a situation where you have, for example, the formation,
But wouldn't it be also helpful if you just had a retainer agreement that showed that the relationship wasn't with Dr. Bernstein, or or a billing statement that billed the corporation and not Dr. Bernstein? Wouldn't that be helpful to contradict?
it could be, Justice McCormick, I'm going to be honest with you, it wasn't submitted to the trial court. Okay, it just wasn't.
That's my point, and we're just reviewing this.
And for all I know, there wasn't a retainer agreement. Dr. Poss and Mr. Bess were longtime attorney-clients. And Dr. Bernstein knew that.
I'm just trying to keep us on track for what our job is.
Yeah, I mean, counsel, I guess, what Justice McCormick is asking goes back to the question that I was kind of asking at the beginning, which was, when someone had a question, who were they asking? And I guess the question that I was, trying to get at in the beginning of our time together was, why wasn't this made clear? And, based on our finding today, what are the implications as we move forward? Is this something that should be made more clear in the future when you have a situation or a circumstance like this?
Well, absolutely, we believe it needs to be made clear. And again, I just refer back to the conflicting Court of Appeals decisions. And in this particular case, Justice Bernstein, the plaintiffs did not produce any evidence establishing the relationship. Dr. Bernstein said he assumed the defendants were his attorneys, but and in his deposition, he said, I may have contacted them once in a blue moon. No evidence that he did, and no evidence of the advice given. And that was with respect to general operation of the corporations, which isn't even the basis of their malpractice claims.
Thank you very much.
Thank you.
Case is submitted. Stand adjourned.